Welcome back. In this video, we're going to be talking about the material in Chapter 16 on written contracts. Before we do that, though, I do have my lawyer joke of the week for you. Now, I will warn you that I've been told that this is quite possibly the worst lawyer joke ever, so you've been warned. It goes like this. There was a lawyer who had a friend from the Czech Republic, so he was Czechoslovakian, and he invited this friend to his cabin out in the woods for the two of them to go hunting and fishing and those types of things. And so in the morning, the two went out to the lake to go fishing, and on their way there, they ran into these two enormous bears. There was one female bear and one male bear. And the male bear ran over to where the people were, and he ate the lawyer's friend whole. And the lawyer was able to run and get away, and he called the local sheriff to come out because he thought the bear was so big he might be able to save his friend if they could maybe kill the bear. So the sheriff got his rifle, and the two went out to the spot where the bears had been, and they were still there. And the lawyer told the sheriff, he said, "My friend is in the male bear. He's the one on the left." And so the sheriff took aim, and he shot the bear on the right. And the lawyer looked back at the sheriff and said, "What are you doing? I told you he was in the other bear." And the sheriff said, "Well, right, but nobody believes a lawyer who says the check is in the mail." Okay, well, whether you agree that that may be the worst lawyer joke ever, let's continue on with our material. And so we'll start with the question that leads us into this topic, which is, when must a contract be in writing to be enforceable? There is a statute, a law, that it exists in every jurisdiction in the United States and has existed for some time about this rule. It's called the Statute of Frauds, and the original Statute of Frauds was passed in England in 1677 in order to require certain kinds of contracts to be in writing. What was going on in England in 1677 was that there was a lot of fraud in the courts. Because of the way their court system was set up, in civil cases, the court did not allow either the plaintiff or the defendant to testify on their own behalf because they assumed that they would both be lying. So what happened was, if a case were going to be brought, the plaintiff would have to find a third-party witness who would come in to verify that the two did in fact have an oral agreement, and in order to prove up the contract. Well, this led to a lot of abuse in terms of fraud and kind of a class of professional witnesses who would come in and testify, basically lie, for money. And so this led to a lot of abuse in terms of the oral contract enforcement rules. So Parliament got together and they said, let's pass a law that says that at least certain kinds of contracts, really important ones, need to be in writing to be enforceable. And we in the U.S., as I mentioned, we've adopted that rule in every jurisdiction, and so we still have it today. Let's take a look at what kinds of contracts are subject to the Statute of Frauds, because not every contract is. A plaintiff will not be allowed to enforce any of the following agreements unless some part of it is in writing and signed by the defendant, signed or acknowledged by the person who is now claiming that the contract doesn't exist. So we can see there are six. There are six categories under the Statute of Frauds of contracts that need to be in writing. The first category is any contract that involves an interest in land. And we'll go through these one at a time and go into a little more detail. But just to run through the list, the first category is a contract for any interest in land. The second is a contract that cannot be performed within a year of its making. Third, any contract or promise to pay the debt of another person, like the guarantee of payment. And then we get to some pretty narrow categories. The next one is a promise made by the executor of an estate to pay the debt of an estate from personal funds. And I abbreviated it here for purposes of the slide, but we'll get into more of the specifics of that and what it means in a minute. The next is a promise made in consideration of marriage. And then the last is any contract for the sale of goods in excess of $500. Now, you might have noticed that it talks about the sale of goods, and so yes, this rule does come from the UCC, and we'll take a look at that. Before I get into the categories, though, and talk in more detail about them, I want to mention when the statute of frauds applies and when it doesn't, because I think a lot of people get this misunderstood. Contracts that violate the statute of frauds, which means, it's another way of saying, it's one of those 6 categories of contracts that needs to be in writing, and it's not. It's just an oral contract. What happens if we have that case is that it makes the contract unenforceable, but not void. Right? It's unenforceable by a rule of law or a defense of law called the statute of frauds. So as we can see here, if the parties execute the contract fully, then it makes no difference whether the contract was written or oral. In other words, the statute of frauds only applies to executory contracts. If you remember that phrase that we talked about earlier, that category from our very first chapter, I believe, we talked about the difference between executed and executory contracts. Executed are those that are finished, both parties have performed. Executory means that one or both parties has not yet fully performed. It's not finished yet. So think of it this way, the statute of frauds only applies to executory contracts. If the contract is executed, both parties have performed what they agreed to, then it doesn't matter whether it's in writing or not. And if you think about it, it makes some sense, because the reason we have the statute of frauds in the first place is to make sure that we have the best objective evidence that a contract really exists. And so if we have the parties' performance, then we have evidence that they had an agreement. Why else would they have performed what they did? So just think of it this way, and you might have been thinking this as we went through the list, especially when we got to that last category about contracts for the sale of goods in excess of $500. And you may have thought, well, I've purchased goods in excess of $500 and I didn't have to sign a writing. Does that mean I can take them back and get my money back? And the answer is no, if your contract is fully executed. So just to make the point clear, if I go to Best Buy and I buy a big screen television, it costs me $2,000, and I pay them the $2,000 and they give me the television. And we don't have any writing, I don't sign any kind of written agreement or anything, and I take the TV home. Does that mean if I don't like it, I can just take it back and claim statute of frauds? Our contract was not enforceable? No, because our contract was executed. Right? I paid money, they gave me the goods. And so that's what we're talking about when we talk about the application of the statute of frauds. Okay, so let's get into the categories. The first category is any contract for an interest in land. Notice I keep saying an interest in land. It doesn't just include a contract for the sale of land. Right? And also, one thing I want to point out with my slides here is that I will abbreviate statute of frauds by putting SOF. So notice that the statute of frauds only requires an interest in land. So this includes things like leases of land, an easement, which is permission to go across someone's land, or even a realtor's listing agreement, which deals with the sale of land by a realtor. So all of those are included in this broad category of an interest in land. Now I have an asterisk there by leases because you can have a valid oral lease in most jurisdictions if it's a short-term lease. So if you have, for instance, what we call a month-to-month lease, like a 30-day lease, that can be an oral lease for land, for an apartment or a house or whatever, and that's good and enforceable, but only on a short-term basis, a month at a time. Most jurisdictions require that anything longer than that, if it involves interest in land, needs to be in writing under the statute of frauds. Also, we'll start to point out some of the exceptions to the statute of frauds. And there are a couple here under this category. The first exception is full performance by the seller. So if you have a contract for the sale of land and the seller performs his or her end, then it doesn't matter whether the contract is in writing or not. If you think about it, how does a seller perform under a contract to sell land? And that is, the seller will prepare a document called a deed, which is necessary to transfer ownership in land, and give it to the buyer. So if the seller has prepared the deed and gives it to the buyer, and then the buyer hasn't paid, the contract doesn't need to be in writing. It's an exception to the statute of frauds. And really, if you think about it, it makes some sense because the deed itself is proof that the parties had an agreement. Why else would someone give a buyer a deed unless they had an agreement to do so? Similarly, another exception in a land sale contract would be part performance by the buyer. This one's a little more detailed, and we can see that the buyer may be able to enforce an oral agreement if he or she has paid part of the purchase price, so not the whole thing necessarily, but part of the price, and has either entered onto, taken possession of the land, or made improvements to it. Right? So again, this is kind of evidence that the parties had an agreement by the buyer's performance. Why else would someone give another person money and then take possession of land or start making improvements on it unless they had an agreement? So that's an exception, this part performance by the buyer. And then last, and I'm not sure this is an exception that's specific to contracts for land, but promissory estoppel. Don't forget about promissory estoppel. Remember, this is an extra contract remedy anyway. And what we're talking about with the statute of frauds is it's a defense that makes a contract unenforceable because it's not in writing if it's one of the 6 categories. So whenever we have a promissory estoppel claim, remember that's an extra contract remedy anyway. And so the statute of frauds really doesn't have anything to say about whether there's a valid promissory estoppel claim. Okay, our next category is contracts that have to be in writing because they cannot be performed within a year of their making. Okay, now this one is phrased kind of funny. You might think, well, it's any contract that's less than a year. And that is accurate to a degree. But really, the way we describe this category is any contract that cannot be performed within a year of its making. And there's some key language in there that I want to talk about. Key language is that the contract cannot be performed within a year. If it can be performed within a year, then it doesn't need to be in writing. It's those that necessarily take longer than 1 year, right? So if I make a promise to you and say, yeah, you can have Fridays off as long as you work here, but we've never agreed on an employment term. So if you're an employee at will, for instance, you could quit at any time or you could be fired at any time. And so that could be performed within a year. So that kind of promise we wouldn't need a writing for. But if I were going to hire you for a special project, and I was going to hire you for a term of 2 years, you were going to work for me for 2 years, and in exchange I was going to pay you a salary for those 2 years, that would have to be in writing because you can't work for me for 2 years within a year. So that necessarily takes longer than a year, and that's the kind of contract we're talking about that needs to be in writing. One other thing I want to note is that the agreement must necessarily take longer than a year from the date of its making. Not from the date that the performance under the contract starts, but from the date the contract is entered into. So, for instance, if I'm going to lease a piece of equipment like a tractor from you, and the lease is a 9-month lease, but we signed the lease today, and I don't get the tractor or take possession of the tractor for 6 months. So 6 months from now, the performance will begin. I'll get possession of the tractor and I'll start making my payments for 9 months. If that's the case, then that would need to be in writing because we can't perform that entire contract, that entire lease agreement within a year of its making because by definition it's going to take 15 months, right, from the day that we sign it. So that's the kind of contract we're talking about under those categories. Next, contracts, or rather promises to pay the debt of another person. Okay, any promise that you make to pay the debt of someone else needs to be in writing to be enforceable. No oral guarantees, in other words, right? A guarantee of payment must be in writing. Now, there's an exception to this. And I've got an example here up on the slide, which I'm going to go through in a second. But the exception has a title. It's called the leading object rule. Okay, and here's what it says. Remember, the category of statute of frauds we're looking at says that any promise to pay the debt of another person needs to be in writing. Okay, no oral guarantees. The exception says if the leading object or the main purpose of the promise to pay the debt of another person is to benefit the guarantor, the one making the promise of payment, then it doesn't need to be in writing to be enforceable. Okay, and let me go through an example of what I mean by the leading object of the promise. And then we have 3 parties here in our boxes. The first is a farmer, and let's say that the farmer is a pig farmer. By the way, this comes from a real case, so it's not purely hypothetical, but the farmer is a pig farmer. And like a lot of farmers, the farmer owes a lot of different companies and entities money and is having a hard time paying them back. So the farmer has pigs that he is feeding, and of course he needs to buy feed, and so he goes to the local farm cooperative to buy feed, ground corn and that kind of thing. But he also owes money to the cooperative, and so they're reluctant to give him the feed because they're afraid that he won't pay for it. And so they're threatening not to give him the feed. So the farmer also owes money to his bank. In fact, he borrowed money, let's say it's operating money to run his farm, and the bank took the pigs that he has as collateral. Okay, well, the bank has an interest in seeing that the pigs get fed, right? Because their collateral will be destroyed if the pigs don't eat. They'll die, and then the bank will lose its collateral. So the bank goes to the farm cooperative and guarantees the farmer's payment. It says, look, I know the farmer right now is not a great risk, but if he doesn't make his feed payments, we, the bank, will. Okay. If you have that situation, then you have the bank making a guarantee of payment for their own benefit, right? The leading object, the main purpose of the bank's guarantee is to protect the bank, not necessarily the farmer, although that's kind of a byproduct of their promise. If that's the case, then an oral guarantee will suffice, right? We don't need to have that in writing. That's the exception we're talking about with the leading object rule. Okay, our next two categories here, I'll run through kind of quickly. The first one is, or number 4 on my list here, is a promise made by the executor of an estate to pay the debt of an estate from personal funds. Okay, it's kind of a long title for the category, and you can imagine it probably doesn't happen very often, but here's the gist of it. When a person dies, they leave behind assets, money, to be distributed to their heirs. There's a person who we call an executor or an administrator who's appointed by the court to take care of the deceased person's final bills and assets and make sure that whatever remaining assets after paying the final bills get to the deceased person's heirs, usually according to a will. Okay, so this executor or representative of the deceased person's estate, one of the executor's jobs is to gather together all the deceased person's assets, gather together all of that person's debt, take the assets and use them to pay off those debts to the extent that he or she can. Sometimes, however, an estate is what we call insolvent, right? Where the estate owes more than it owns, right? And so there's not enough assets to pay the debt. So let's give you a real life or a real example to put some flesh to this. So let's say that my father dies and he is insolvent. His estate is insolvent. He doesn't have enough money or assets to pay his creditors. But one of his creditors happens to be his sister, my aunt, who made a legitimate loan, to my dad during his lifetime. And, they drew up a promissory note. They had a payment schedule and everything. It wasn't just an under-the-table type loan. It was a legitimate loan that he was paying back. So she's listed as one of the creditors. And I am appointed to be the executor. And I look at the estate and then the assets, and I look at the debts, and I realize very quickly there's not going to be enough money to pay all the creditors 100% of what they're owed. So I go to my aunt, and I make a promise to her personally. And I say, look, I know you made this loan to my dad at a time when he really needed the money, and there's not enough assets in this estate to pay everyone, including you, 100% of what you're owed. So here's what I will do. I promise personally, out of my own funds, that if there's not enough money in the estate to pay you fully, then I'll make up the difference. I'll make sure you get paid 100%. That kind of promise from me as the executor of the estate to pay the debt of the estate has to be in writing to be enforceable. That's the category that we're talking about in the statute of frauds. You can imagine how often this comes up. Not very often, because we don't usually have executors willing to make that kind of a promise to pay from personal funds the debt of an estate, but it is one of the categories of the statute of frauds. Likewise, this next one, promises made in consideration of marriage. We don't see this one, honestly, very often, but let's say I come to you and I say, will you marry me? And you say, no. No. And I say, did I happen to mention that I'm independently wealthy and I own my own string of private islands in the South Pacific, and if you marry me, then I will give you one of these islands to be yours. And you say, suddenly I'm much more attracted to you. Yes, I will marry you, right, based on that promise. Well, if we end up marrying and then I don't transfer you the private island like I promised, and you want to sue me for breach of contract, you can't. Why? Because that was not in writing, right? We didn't get it in writing. That's one of the categories of statute of frauds, is promises made in consideration of marriage. Now, I know what you might be thinking is that, well, you'll just divorce me and get the island or at least half of it anyway, and you're probably right. But that's the category for the statute of frauds. One place we do see this, though, and I think one way to make this still relevant is in prenuptial agreements, right? A prenuptial agreement is where two parties who are going together to be married prior to their marriage sign an agreement that basically says, that where each spouse basically says, whatever assets I own currently before we're married, I'm going to keep, and you will make no claim to. And then the other spouse will make the same kind of promise, right? Any assets that I own, I will keep, and you will make no claim to. And both parties basically agree to make no claim to each other's premarital assets. And then they sign the agreement. Well, this is the kind of agreement that is made in consideration of marriage, and so under the statute of frauds, prenuptial agreements need to be in writing to be enforceable. So this is where we would see it in modern times.